There are certain things in life with a minimum age limit, like driving, drinking alcohol, and even voting. But is there a minimum age limit for your constitutionally protected rights? That was a question Caleb Reese and others wanted to ask when they filed a lawsuit against the Bureau of Alcohol, Tobacco, Firearms, and Explosives regarding 18 U.S.C. sections 922b1 and c1, which prohibit the selling of handguns to 18 to 20-year-old adults. So we'll look at this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. I'm glad you could join me today. This question of handgun ownership by 18 to 20-year-olds has been an on-again, off-again thing I've seen over the years, and we finally have a decision, this case out of the Fifth Circuit Court of Appeals. I'm not saying that this case is done, it's not going to be appealed to the Supreme Court, but it's worth looking at the details to get an understanding of what's going on and the arguments on both sides. So that's what we'll do next. Now, if you head to the website, you can find the article with all the links to my resources there. But before I talk more about that, I'll do that maybe at the end of the episode. Let's get into this question of Reese versus ATF. Caleb Reese, the Firearms Policy Coalition, the Second Amendment Foundation, Louisiana Shooting Association, and Emily Naquin sued the Bureau of Alcohol, Tobacco, Firearms, and Explosives, their director, Stephen Dettelbach, and the acting U.S. Attorney General James R. McHenry III, claiming that federal law and regulations violate their rights protected by the Second Amendment. Appellants filed suit in the district court against the Bureau of Alcohol, Tobacco, Firearms, and Explosives, its director, and the Attorney General of the United States, challenging the constitutionality of 18 U.S.C. sections 922b1 and c1 and their attendant regulations, including 27 CFR sections 478.99b, 478.112a, and 478.96b. These provisions, in effect, prohibit federal firearms licensees from selling or delivering handguns to adults under the age of 21. Appellants contend that the federal laws unconstitutionally infringe on their right to keep and bear arms under the Second Amendment and deny them the equal protection under the Due Process Clause of the Fifth Amendment. The Fifth Amendment doesn't have an equal protection clause, and I don't see how the Due Process Clause establishes one. The case continues with the actions of Congress. Congress enacted the Omnibus Crime Control and Safe Streets Act in 1968, and inter alia prohibited FFLs from selling certain firearms to certain purchasers based on the purchaser's age. The first challenge provision states, it shall be unlawful for any licensed importer, licensed manufacturer, licensed dealer, or licensed collector to sell or deliver any firearm or ammunition to any individual who the licensee knows or has a reasonable cause to believe is less than 18 years old, and if the firearm or ammunition is other than a shotgun or rifle, or ammunition for a shotgun or rifle, to any individual who the licensee knows or has a reasonable cause to believe is less than 21 years of age. Now, the Omnibus Crime Control and Safe Streets Act establishes two sets of restrictions based on age. First, it prohibits licensed dealers from selling firearms to anyone under the age of 18. Second, it prohibits the sale of any firearm other than a shotgun or rifle to anyone under the age of 21. The law goes on to state, additionally, Section 922c1 prohibits FFLs from selling such a firearm to a person who does not appear in person at the licensee's business premises, absent a sworn statement that they are 21 years or more of age. So if you purchase a firearm from a licensed dealer, you're supposed to provide a sworn statement that you're at least 21 years of age. Now, based on this law, the ATF promulgated regulations. ATF implemented regulations prohibiting the sale of firearms other than a shotgun or rifle to adults under 21. 27 CFR 478.99b, for instance, states in part, a licensed importer, licensed manufacturer, licensed dealer, or licensed collector shall not sell, deliver any firearm or ammunition other than a shotgun or rifle or ammunition for a shotgun or rifle to any individual who the importer, manufacturer, dealer, or collector knows or has a reasonable cause to believe is less than 21 years of age. Now, between the law and the regulation, adults under the age of 21 were denied their right to purchase a handgun. As a result, 18 to 21-year-olds may not purchase handguns from FFLs. The Act and regulations do nothing to prohibit 18 to 20-year-olds from owning, possessing, or carrying handguns, nor does it prohibit them from buying handguns in an unlicensed private market or receiving handguns as a gift. That's an interesting loophole. Someone between the ages of 18 and 21 can own a handgun, but cannot buy one except on the private market. Since it is a federal crime to purchase a firearm for someone else, known as a straw purchase, that leaves people who can legally own a firearm in quite a conundrum. How can you own a firearm unless you purchase it? And since you can't purchase one from a licensed dealer, you're forced to do so from an unlicensed one, which I doubt was ATF's plan when they proposed this rule. Appellants allege that this handgun ban is inconsistent with our nation's history of firearm regulation and thus unconstitutionally infringes on their Second Amendment right to keep and bear arms. Telling someone they can own a firearm, just not purchase one, seems to infringe on a person's right to keep and bear arms. Let's look at the argument about purchasing firearms. The government makes two main points in their argument. Addressing the first question under Bruen, the government contends that the Second Amendment's plain text does not cover the conduct that sections 922b1 and c1 prohibit. The government argues that a limited ban on the purchase of handguns from FFLs is not an infringement on the Second Amendment rights, and in any event, 18 to 20-year-olds are not among the people protected by the right. The belief that a ban, no matter how limited, does not infringe on the right to keep and bear arms defies logic. I guess to a government that believes they have the right to censor free speech and press, infringement means something different. The idea that an 18-year-old could not only own a gun but use one to fight for our country but is not part of the people is as obscene as saying someone is not a part of the people because of the color of their skin, where they were born, or any other arbitrary attribute. We reject these points, then move to Bruen's second inquiry, whether the government met its burden to demonstrate historical analogs supporting the challenge regulations. The Fifth Circuit rejects the government's argument about the Second Amendment, then moves on to the historical analogs that the Supreme Court used as precedent in the Bruen case. Contrary to the district court's assumption, the government denies that the plain text of the Second Amendment establishes a right to purchase a firearm at any time from any source. Contrary to the government's position, they don't get to determine when, where, or under what circumstances someone can exercise a right protected by the Constitution. In other words, when the plain text of the Second Amendment protects a right to keep arms, that includes purchasing them. The government has to provide an extremely good reason to violate the due process rights of the American people, regardless of their age. Due process is defined as an established course of judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. The government keeps digging deeper. It emphasized that 922b1 only limits the sale of handguns by a particular type of seller, FFLs, to a particular class of buyer, under age 21. Of course, the words purchase, sale, or similar terms describing a transaction do not appear in the Second Amendment, but the right to keep and bear arms surely implies the right to purchase them. Again, the right to own logically includes the right to purchase, which means the question isn't whether or not there is a historical analog for these age restrictions. The threshold textual question is not whether the laws and regulations impose reasonable or historical grounded limitations, but whether the Second Amendment covers the conduct commercial purchases to begin with. And according to the plain text of the Second Amendment, yes, the Second Amendment covers the purchasing of firearms. The next part of the government's argument is that 18 to 20-year-olds are not part of the people under the Second Amendment. The government next asserts that 18 to 20-year-olds are not part of the people whom the Second Amendment protects. This argument is based largely on common law's recognition of 21 years as the date of legal maturity at the time of the founding, and the fact that legislatures have long established minimum age requirements for various activities. Since when has personhood been age dependent? While in ages past, yes, 21 may have been the age of legal maturity, what does that have to do with a natural right protected by the Constitution? The operative clause of the Second Amendment states that the right of the people to keep and bear arms shall not be infringed. There is no age or maturity restrictions in the plain text of the amendment, as there are in other constitutional provisions. This suggests the Second Amendment lacks a minimum age requirement. So the Second Amendment doesn't have a minimum age requirement. What about this not a person nonsense? Moreover, in the unamended Constitution and Bill of Rights, the phrase right of the people appears in the First Amendment's Assembly and Petition Clause, the Fourth Amendment Search and Seizure Clause, the Ninth Amendment. All of those references confer individual rights and undoubtedly protect 18 to 20-year-olds as much as 21-year-olds. As I've always said, any right of the people is an individual right, and unless restricted by the Constitution, age doesn't matter. Still, the government emphasizes that the right to vote from the founding up to the 26th Amendment was typically reserved for citizens over 21. Thus, because voting is a hallmark of membership in the polity, 18 to 20-year-olds were originally and now remain excluded from the political community described in Heller. Is it just me, or is the government simply ignoring the fact that it wasn't the Constitution or the federal government who put age restrictions on voting before the 26th Amendment? They also seem to have forgotten Section 2 of the 14th Amendment. The court noted the issues with this position. This argument is incompatible with Second Amendment precedent, nonsensical when considered against the backdrop of American suffrage, and contradicted by the history of firearms use at the founding. So far, I'm with the Fifth Circuit, but is that the only argument against the not part of the people nonsense? Thus, to say that the people covered by the Second Amendment is limited to those who are part of the political community at the founding would imply excluding law-abiding adult citizens based on property ownership, race, or gender, just as denying arms as only those arms in existence in the 18th century borders on the frivolous. Likewise, attempting to limit the people to individuals who are part of the political community at ratification is ludicrous. Sounding better at the Fifth Circuit. With these two strikes against the rules, can the courts find a third? Finally, the history of firearms use, particularly in connection with the militia service, contradicts the premise that 18 to 20-year-olds are not covered by the plain text of the Second Amendment. That seems to make sense, especially since our sixth president, John Quincy Adams, drilled with the Massachusetts militia, I believe, at the age of 8. The Second Amendment's prefatory clause states that a well-regulated militia being necessary to the security of a free state. While Heller recognized that the central concept of the right to keep and bear arms is self-defense, the prefatory clause announces the purpose for which the right was codified, to prevent elimination of the militia. The framers knew all too well the dangers a disarmed and defenseless public could face under monarchical control. Since the purpose of the Second Amendment is the question of self-defense, why would an 18-year-old be able to own a handgun but not purchase one? The Second Congress consequently enacted the Militia Act of 1792, which stated in part that each and every free, able-bodied white male citizen of the respective states resident within who is or shall be of the age of 18 and under the age of 45, except as herein accepted, shall severely and respectfully be enrolled in the militia. If an 18-year-old can be part of the militia, why not purchase the weapons that would be necessary to join? Finally, the government argues that mere participation in the militia was not enough to establish Second Amendment protections because, well, black men served in the militia but were otherwise barred from possessing arms, and 2, Virginia by law disarmed men who refused to take a loyalty oath while still requiring them to enroll in the militia, albeit without firearms. The treatment of blacks is hardly probative as an 18 to 20-year-old because race-based classifications would apply regardless of age. Are we supposed to enforce our laws based on the racist policies of the past? And how does a person's race equate with their age when it comes to purchasing a handgun? So how did the Fifth Circuit decide this case? Ultimately, the text of the Second Amendment includes 18 to 20-year-old individuals among the people whose right to keep and bear arms is protected. The federal government has presented scant evidence that 18 to 20-year-olds' firearms rights during the founding era were restricted in a similar way to the contemporary federal handgun purchase ban, and its 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. In sum, 18 U.S.C. sections 922b1 and c1 and their attendant regulations are unconstitutional in light of the nation's historic tradition of firearms regulation. We reverse the district court's judgment and remand for further proceedings consistent with this opinion. A nice, clear, concise answer. Both the laws and their regulations are unconstitutional. Now the court sends the case back to the district court to proceed based on the circuit's opinion. The Fifth Circuit has said the law and regulations are unconstitutional. So what now? I've already pointed out that Caleb Reese and the rest have to go back to the district court for them to proceed based on the circuit court's case. If all goes well, the district court will find accordingly. Hopefully, this decades-long infringement on the rights of the people, all people, to keep and bear arms will be ignored by the court. I wonder if the ATF will rescind their regulations. Will Congress repeal the law? Personally, I won't hold my breath. I wonder, what other infringements on our rights can we find? Will we find a redress for our grievance in the courts? Again, I wouldn't hold my breath. That said, I'm happy for all those 18 to 20-year-olds in this country who can once again fully exercise their right to keep and bear arms without threat from the ATF. So all you 18 to 20-year-olds that want to go out and buy a firearm, have at it. Maybe bring a copy of this decision just in case your FFL hasn't heard. But the regulations are found unconstitutional. The law is found unconstitutional and therefore void, empty, and meaningless. And we have the Fifth Circuit to say that it's so. Let's go out and exercise those rights. Now, there's a lot of other areas and a lot of other rights that are being infringed, which is why I hope you come and join us at the Constitution Study. Check out the website, constitutionstudy.com. You can find all of my articles. You can find the links to all of my sources. And best of all, you can ask a question. If you want to learn more about something, there's an Ask a Question feature. There's a button right there on the website. You can ask me a question. I also hope you'll head to the store, maybe purchase a book or donate to the cause. All of it goes to keeping the Constitution Study up and running. I don't take a salary or take any money out of this. I pay for it all. So anything you do to help would be, well, helpful. I also hope you'll check out a couple of our partners. For example, The Miracle of America. It's a great little lesson from the Pilgrims through the drafting of the Constitution, talking about the history of America. What makes America a miracle? Put another way, what makes America great? Now, I made a deal with the publishers to get you a lesson to try it absolutely free. So if you go to constitutionstudy.com/1776 study guide, that's the numerals 1776 study guide, you go to a custom landing page where you can not only read about the course, but you can enroll for your free lesson on God's natural law. Really important thing to understand. And if you like the course, you can sign up. The whole thing is just $17.76, but you start by going to constitutionstudy.com/1776 study guide. Or maybe check out Patriot Mobile, America's only Christian conservative wireless provider. You get great coverage, 4G and 5G across the country. They have 100% US-based customer service. Best of all, they take their funds and they invest in other entities and companies that are trying to protect our rights, like freedom of religion, freedom of speech, that support our veterans and our first responders. They're not out to antagonize what makes America great. They're out to help enrich what makes America great. Now, if you go to patriotmobile.com/constitution, you can find a plan that works for you. But best of all, if you use the code Constitution at checkout, you'll also get free activation. So once again, that URL is patriotmobile.com/constitution to find a plan that works for you. Don't forget to check for discounts. And then be sure to use the code Constitution at checkout to get free activation. Whatever you do, I hope you'll take this episode. I hope you take a lot of the projects we put together and share them. That act of sharing, that act of getting up off the couch and doing something is really important to keeping America free. If we want to remain the land of the free, we have to be brave enough to engage. And a way to start is just share the links to the stories, to the videos, to the articles. Share them. When you do, you're sharing more than just the Constitution Study. You're actually sharing the blessings of liberty that make this country the greatest place in the world. I hope you come back next time and maybe bring a friend or two to the Constitution Study.
Love the neighbors and have a few good friends.